I'll request my colleague, Advocate Chinmay, to give a small introduction of our guest speaker. Over to you, Chinmay.
Thank you, Shraddha. Good morning, everyone. I'd like to give a small introduction about Anil sir. Sir has completed his law degree from Punjab University and his master's from LSE. Sir has over 3 decades of experience in conducting civil, criminal, and constitutional matters in various high courts and the Supreme Court of India. In addition to this, Sir has also been a part-time lecturer at the Punjab University. He has authored a book on NRIs and surrogacy, in addition to other globally published works. As the chairperson of the Task Force for Policy Procedures for Resolution of Grievances of NRIs, Sir has authored 5 papers for the government of Punjab and helped in enacting various laws and rules. Sir has also conducted many inter-country litigations on parent-child removal and child abduction. Sir has been persistently pushing for India to sign the Hague Convention on interparental child abduction. His report as the amicus curiae formed a part of the judgment of the Punjab and Haryana High Court, making a recommendation to the Law Commission of India to sign the Hague Convention. Sir has held many distinguished appointments, including as a resource person for training judicial officers at the National Judicial Academy at Bhopal and and at the Chandigarh Judicial Academy. Sir has also been appointed as the honorary professor at NUALS Kochi. We are indeed privileged today to have Sir here with us and to hear him speak. I'd like to request Sir to please conduct the lecture.
Thank you very much. Thank you, Shraddha, and thank you, Chinmay, for the wonderful introduction and giving me this opportunity of sharing my views on a highly debatable and a highly litigated now, I would say, subject in which there is such a time gap between children being moved out from India to different jurisdictions that it is becoming an extremely tough proposition for people to battle out of litigation in these circumstances. Now, before I come to the proposition, why do I say that this is litigation which is in a quandary? I say so because we have, on the one hand, a law under the Hindu Adoption and Maintenance Act, which gives us the exclusive rights as Hindus to adopt children as a personal law. Can people please mute their mics? Then came the Juvenile Justice, Care and Protection of Children Act. It came in 1986. It was amended in 2010. It was amended in 2012. But ultimately, it was amended drastically in 2015. Now, the necessity for amending the Juvenile Justice Act came because India had signed and acceded and ratified the United Nations Convention on the Rights of the Child. This was done by India, and thereafter, India, after the ratification in 1992, India was obliged to make changes in domestic laws to incorporate the provisions of the convention. So, simultaneously came the overall in adoption law in India. Lakshmikant Pandey 1, 2, and 3 Supreme Court judgments in 1986, 88, and 90 brought about the change. Adoption was a very grey area and there was a lot of trafficking of children. So the Supreme Court slowly brought in the concept of adoption under an independent act, though traditionally and conventionally, the Guardian and Wards Act 1890 used to be invoked whenever a child was adopted, foreign adoptive parents would take a guardianship order and then the child would leave the country. So, with the coming in of the Supreme Court judgments, Supreme Court directed the government of India to create a body which would regulate the process of adoptions. Now, this process was handed over to Central Adoption Resource Agency. It was at that time known as CARA. Now, under the 2015 Act, CARA is a statutory body because it is now called Central Adoption Resource Authority. Now, adoption under the 2015 Act, the JJ Act, is a chapter separately, and to foster the spirit of providing a home and a family to a child, the regulatory procedure of adoptions, inter-country adoptions, intra-country adoptions, domestic adoptions, relative adoptions, everything is covered into it. Now, before we get into what the JJ Act does, at the outset, we must first clarify and be very clear that Shabnam Hashmi's judgment by Justice Gogoi is very clear in 2015 that the Juvenile Justice Care and Protection of Children Act 2015 is a secular law. Being a secular law, it is available to every community, Muslim, Christian, Hindu, Jewish, Parsi, for adoption of children in India. So regardless of a family adoption, inter-country adoption, intra-country adoption, parties or residents of India, citizens of India, or foreign nationals, of course, also, are free to adopt under the JJ Act. But Hindus as a class by themselves, in matters of adoption, are governed by the Hindu Adoption and Maintenance Act of 1956. As you are all aware, Hindus, who constitute the largest majority religious identity in India, is governed by the Hindu Marriage Act, the Hindu Adoption and Maintenance Act, Hindu Minority and Guardianship Act, and Hindu Succession Act. So these are personal laws, and these have also got extraterritorial application. So at the outset, I want you to understand that if you are a Hindu by religion, and you have been an Indian person of Indian origin, and you have now acquired a foreign nationality. So whether you are Australian, Canadian, German, British, Swedish, you will remain a Hindu by religion. And if you are a Hindu by religion, Hindu law will apply to you in matters of marriage, in matters of divorce, and in matters of all personal law issues. So therefore, coming to the question of adoption. Now, the Hindu Adoption and Maintenance Act of 1956 was enacted to say that it is an act to amend and codify the law relating to adoptions and maintenance among Hindus. So, anybody who is Hindu by religion has an option to adopt under Hindu law. And under Hindu law, the process of adoptions takes place in accordance with the provisions of Hama. So, Section 7 talks about the capacity of a Hindu male to take an adoption. Section 8 talks of a capacity of a Hindu female to take an adoption. Then persons capable of giving an adoption under Section 9. Then under Section 10, the provision is persons who may be adopted. And then comes other conditions of a valid adoption. So it is quite simple. The person giving an adoption should be competent to give. The person taking an adoption should be competent to take. And how does it take place? Section 11, subsection 6I says, the parents giving an adoption will give, the parents taking an adoption will take. You may perform a ceremony of Datta Homan, you may not. But that act of giving and taking by parents on both sides is enough. That is the legal requirement under Hama. So you need not do anything more. You may have witnesses, friends, you may have a ceremony, you may have a pandit, priest, whatever, and that is it. But then section 16 says that whenever you register the adoption, there will be a presumption in law that it has taken place in accordance with the provisions of Hama. But a note of caution, there is no compulsory registration of an adoption. Like you do a rent deed or you do a sale deed or a transfer deed or any other deed, there is a compulsory mandatory provision of registration under the Registration Act. Under the Hindu Marriage Act, under the Hindu Adoption and Maintenance Act, there is no mandatory provision for registration. Now, because it is so, under section 12, the provision says that from the day the adoption ceremony of giving and taking takes place, the adopted child will sever all ties with the natural parents and will become the child of the adopted parents. So now let us consider a hypothetical situation that if the giving and taking ceremony of adoption takes place on a particular day, but no adoption deed is written down, and the adoption deed is written down, let us say after 3 or 4 years, the material date for adoption will be, under the Hindu law, the date when the handing and taking over had taken place. The answer is simple. The registration only relates back to the date of the ceremony of adoption. So it is not like a normal commercial transaction or any other deed that the rights flow from the date of the deed. In such a situation, the child has already severed his ties from the date he was handed over and taken over. And therefore, to say that the adoption will take place from the date the deed was registered will not hold forth. So this is insofar as a deed under Hindu Adoption and Maintenance Act is concerned. Now, what is the situation and where we are in a flux? Let us now jump to the Juvenile Justice, Care and Protection of Children Act 2015. Now, under this act, which was an act dealing with the juveniles in conflict with law to start with, there was a sea change, as I told you, in amendments, and different issues came to fore. So, from an act which related to orphan, abandoned, and surrendered children and juveniles in conflict with law, now the expansion in the arena of adoptions has also come to inter-country parental adoptions, intra-country parental adoptions, and all family adoptions in which children are to be relocated abroad. So now in chapter 7 of the JJ Act, there is a special set of sections from 39 to 55 dealing with rehabilitation and social integration. So it talks of children who need protection, children in institutions, shelter, foster care, sponsorship, children's home, rehabilitation. And then chapter 8 graduates to adoptions. Then Chapter 8 is a complete set of provision in itself. Now, Section 56 of the JJ Act deals exclusively with how this adoption process takes place. So, Section 56, which is the basic provision, says that adoption shall be resorted to for ensuring right to family for orphan, abandoned, and surrendered children as per the provisions of the Act and the rules and so on. So, very clearly, 56.1 talks of orphan, abandoned, and surrendered children. Then, 56.2 says adoption of a child from a relative by another relative, irrespective of the religion, can also be made as per the Provisions Act and the adoption regulations on this topic. So, first category is orphan, abandoned, surrendered children, and second is adoptions by parents. So, if you are a Hindu, you have the option of going under the JJ Act, but you also have your right intact of going under Hama. Now, what is the conflict area and debatable area? And that is 56.3. Now, 56.3 says nothing in this act shall apply to adoption of children made under the provisions of Hindu Adoption and Maintenance Act 1956. Now, this provision in the act substantively divorces all Hindu adoptions from the application of the Hindu Adoption and Maintenance Act. Now, the conflict area comes when a court has to see whether 56.3 has to be read alone or 56.3 has to be read with 56.4 and 5. 56.4 says all inter-country adoptions shall be done as per the provisions of this Act and adoption regulations. Now, this in a way says that the procedure for adoption of children, which is prescribed for other countries in inter-country matters, will also apply to those. Now, this is a question of judicial interpretation, which we will come to later. Then 5 is a little more away. 5 says, any person who takes or sends a child to a foreign country or takes part in any arrangement of transferring a child in violation of the JJ Act. Now, the quandary, the issue of the adoption wavering comes when 56.3 and 4 and 5 are read into 3. And this is where it becomes debatable. So, is 56.3 to be read alone, or 56.4 and 5 also have to be read? Now, 59, 58 talks of adoption by parents in India. 59 talks of inter-country adoption of orphan children, and 60 talks of inter-country relative adoptions, and 61 talks of the procedure, and 63 talks of the effect of adoption. Now, before we venture into any further discussion, I must also tell you that India has signed the Convention on Protection of Children and Cooperation in respect of inter-country adoptions in 1993. Now, this international convention is meant to facilitate the movement of children from country to country when children are adopted and taken abroad. So, all the countries which are signatory to the Adoption Convention exchange information about children available for adoption, parents willing to take in adoption, and country to country, they interact with each other through a body called a central authority. So every country will make a central authority. Let us understand that there are Indians in America, England, Canada. So if they want to adopt a child from India, they will go to the central authority in their country. They will register there. They will register also on the website of India. It's called Carings. Their foreign authority will sponsor them. CARA will assess them in India. Their turn will mature. They will be offered a child. Matching will be done. And then the process follows. So this is insofar the process of orphan, abandoned and surrendered children is concerned. So ultimately, when all these systems of checks, balances, and welfare of the child is ascertained by these bodies, and it is ensured that there is no trafficking of children, that the adoption is in the best interest of children, that CARA in India or as a central authority issues a no objection certificate that the child is free to leave the country. So until and unless this NOC is given by the JJ Act, under the JJ Act, the child cannot leave the country. So this requirement of an NOC from CARA has been incorporated in the JJ Act because of India signing the Inter-Country Adoption Convention. Now, here itself, I must tell you that the Inter-Country Adoption Convention also says that there is a system of law prevailing in a country, a domestic law, let us say like Hama. In that situation, the domestic law of adoption applicable internally in the country will also be recognized under the convention, but CARA as the central authority has to certify and verify that this system of adoption has been duly followed, duly observed, and properly applied to the domestic adoption. So now we graduate into the disturbed or complication area. Now, the Section 68 of the Juvenile Justice Act empowers CARA and the government to enact rules and regulations for a process to be followed in terms of inter-country and intra-country adoptions. Now, there is no dispute on how orphan, abandoned and surrendered children have to be adopted. The system I have just told you, the regulations provide a system of checks, balances, which have to be undergone. You have to wait for a child to be given to you, offered to you. There is a matching. There is ultimately, the matter is referred to a committee which verifies. Previously, it would go to a court, but CARA in its wisdom has amended the regulations and the word court has been replaced by a district magistrate. I am not in agreement with this because according to me, the judicial application of mind, the mature wisdom of the court, the experience of the court in overseeing an adoption is much more better vested with the court, not with the magistrate who is just an executive authority. So that be so, whatever it is, once the district magistrate gives a nod, then CARA takes over, processes and gives the NOC. But then the question is, once a domestic adoption has taken place under Hindu law, there is a non-resident Indian of foreign nationality who was an Indian. He has taken the child of a relative in adoption. They have adopted the child by doing a giving and taking ceremony under Hama. They have done it in their village, in their town. They have additionally taken the precaution of registering a deed, which is attested, witnessed, notarized. They have also taken the precaution of getting birth certificates in their name. They have even taken the precaution of taking an Aadhaar card. They also try to apply for passports. But even for a passport, the passport authority starts talking of an NOC from Kara. Now, under the Passports Act and the passports rules, passport officer is nobody to ask for an NOC from Kara. But they have made their regulations, or they have made their administrative guidelines under the passport manual. There are judgments to the effect that there is no bar on the passport authority issuing a passport unless the grounds of the Passports Act are met, and Kara's NOC is no requirement there. But no passport officer issues a passport to an adopted child without a certificate of Kara. It is constitutionally wrong, but the fact of the matter is it goes on. So in that situation and circumstance, the problem comes when a person goes to Kara and says, I have adopted the child. Here is the ceremony of giving and taking. I am living with this child for 1 year, 2 years, for so many years. I want to take the child out of the country. I have applied for a passport. Please give me an NOC. Kara started saying, no. You can't do this. You have to register with us. You have to go back to your home country, get an approval or a clearance or a recommendation, and then we will process. So the question is, what is the state and what is the legal validity of the Hindu adoption which has taken place already? Under Section 11, Hama, it is irreversible. So do you go back and return the child who has already been living with you, bonded with you? Which procedure is to be followed? Now, I was an amicus in 2 matters in the Punjab and Haryana High Court, and there was another matter in Delhi High Court where this issue was gone. And the courts in Punjab and Haryana and Delhi were of the view that in matters of inter-country adoption between relatives, family giving and taking an adoption, Kara's procedure of checks and balances is not required. And the logic is simple. The parents giving and taking an adoption are Kara. They are performing the role of Kara. A parent giving his child in adoption is the best judge of what he is doing. There is no need for Kara. Likewise, a parent taking an adoption is taking a relative's child. Where is Kara to come in? But Kara, in its overawing role, as I may say, has bypassed 56(3) and taken over Hindu adoptions. So after these judgments came, Kara amended their regulations on 17th of September 2021 and said any adoption taking place after 17th of September 2021 will be governed by the procedure under Regulation 68, which means you have to go to the agency in the foreign country. You will, Kara, that country's authority will process your request, send it to you, send it to Kara in India, then Kara will send it to the district magistrate, then there will be a process of approval. But the million-dollar question is, what happens to the Hindu adoption? Where does the child go? It's irreversible. Can these adoption regulations of 2022 nullify Hama? And can these adoption regulations water down Section 56(3) of JJ Act? As a layperson, can regulations tone down, read between, or find overawing, over-influencing application over a statute made by Parliament? Answer is no. But the question is, they've done it. The second thing, What is the basis of this cutoff of 17th of September 21? So what is effectively Kara saying? Kara is saying all adoptions which have taken place before 17th of September 21, we will give a support letter, we will do a verification and we'll let you. But anything after 17th of September 21, you will have to follow the procedure under the adoption regulations of starting all over again. Now, a question which I ask myself is, are Hindus of two categories? One category of Hindus is before 17 September 21, and second category of Hindus is after 17 September 21. Can you make an artificial classification among Hindus? What is the nexus with the object sought to be achieved? What is the logic? How can Kara discriminate between two categories of Hindus? There has to be equality of law and equal protection of laws. Article 14 is violated. So this logic to me is absolutely out of any legal support. Nobody has challenged it. I did challenge it in one matter, but then we followed the procedure of taking a district magistrate certificate, and the children were able to leave. The Viris was not gone into. So this, according to me, the mandate of Kara in amending their regulations and prescribing a procedure which nullifies Hindu adoptions is, in my humble view, void ab initio. It's absolutely illegal. Let us consider another situation. Now, the regulations say that adoptions in which adoption deeds are registered after 17/9/21, the amended regulation will apply. Now, the question is, if there is a Hindu adoption under Hama and the date of the giving and taking ceremony is before 17th of September 21, but the date of the adoption deed registration is after 22. Let us say there was COVID. Let us say parties were not able to form that registration part. Can the regulations say, no, we will read the adoption from the date the deed is registered. We will not accept the adoption from the date of the ceremony of adoption. Can Kara, by its regulations, change the effect of adoption under section 12 of Hama? No. But in fact, it is there. Now, I don't understand what is the need for Kara to take over inter-country adoptions among Hindus between relatives. Now, they say it is required by the convention, but I think they have to do some fine reading of the convention. The convention says if you have a domestic system of adoption in a country as a second system accepted by law, Kara should approve it. Let Kara follow the procedure of seeking a verification that the adoption by the relative is in the best interest. Let the matter go to the district magistrate. Let him take it to a verification committee or a child welfare committee. It has been done a number of times. There is a 4-5 member committee. They call the adopted parents. They call the adoption parents taking adoption. They view the foreign home online. They talk to other children in the family, and they prepare an exhaustive report. There is a system of checks and balances by which even a Hindu adoption to be verified. The question which I put to myself is, once the adoption has been done under Hama, if there is a presumption in law that it is in the best interest of the child, because there is a relative giving an adoption, then there is a relative taking an adoption. Who will give his natural born child to somebody unless and until he is very sure that it is in the best interest of the child? So, should Kara be invading into homes in Hindu adoptions? Should Kara be sitting in judgment over the validity of the adoption? And can CARA come to a different conclusion? And if so, how will the adoption be treated? Section 12 says it is irreversible. Unless, of course, it is annulled by a court of competent jurisdiction. But can CARA be the court? Can CARA judge the Hindu adoptions? It's a debatable issue. And in my view, CARA should be concentrating on expediting adoption of orphan, abandoned, and surrendered children by a fast-track process instead of interfering in Hindu adoptions. Now, if CARA wants to take over adoptions under HUM also, then Section 56(3) should be deleted. Section 56(3) says that nothing in this act shall apply to adoption made under HUM. Why retain this? And then why even keep HUM? Let us take away the provisions of HUM altogether. So this is a question which has to be settled by an interpretation by a constitutional court. Now, under Regulation 67(3), the procedure for adoptions before 17,921 is that where the adoption deed, now it says where the adoption deed has already been executed. Now, I don't understand how they have written the word where the adoption deed has already been executed. The language should have been where the adoption has been completed in accordance with the provisions of HUM. Because the effective date is the date when the adoption takes place, not the date when the deed is registered. Before the commencement of the regulation, the requisite documents supporting the facts of the adoption deed shall be verified by the district magistrate in so and so form. Upon receiving the verification as to so and so, CARA will comply with the provisions of Articles 5 or 17 from the receiving country. So they have to verify from the receiving country. Then upon receiving such certificate, CARA shall issue an NOC for Hague countries in respect of the adoption, or issue a support letter accepting the adoption from the government department. So depending on whatever procedure is followed, either a support letter or an NOC is given by CARA. Now, this is what is being done in adoptions before 17,921. I correct myself. In adoption deeds registered before 17,921. I think the wording is flawed. The flaw is that it should read from the date of adoption under HUM. So that be so, then comes the normal procedure, and that is how it is done. So clearly we have a situation where there is divergence of view of CARA. Now, come to the practical situation. There have been instances where people have been waiting for 2 years, 3 years, up to 5 years, waiting for CARA to give an approval. Now, CARA doesn't do so on its own. CARA sits over it. It gives stereotyped replies, saying follow the procedure under the regulations. Now, CARA itself is a body comprised of government officials. And I think what they really need this, that the chief executive officer of CARA
आवाज अरे
Hello. Hello.
Yeah, it's not
In
audible.
Yeah, in between it just went or pause. I don't know. There was some internet glitches.
Okay. So now is it okay now?
Yeah. Now it's audible. It's audible.
I think we lost. It was probably at your end, I think.
No,
Anyway,
I don't know. There was some.
anyway, so now
Okay.
what I was saying was that uh, the yawning gap of interpretation between how the provisions are to be read led the matter to be pending before Kara in different adoptions for a number of years. It is still happening now because, according to me, if there is an adoption under Hama, for Kara to say that you will adopt, you will have to follow the procedure of going back to your country of origin for sending a request for approving the adoption, getting a study report from there, then Kara processing it and following the procedure, which is applicable to orphan, abandoned, and surrendered children. I think this violates the provisions of Hama, where the adoption is irreversible. And this also contradicts and conflicts Section 56(3) of Hama, which is very clear that nothing in the Juvenile Justice Act shall apply to adoption of children under Hama. The Supreme Court, in a public interest litigation in Temple of Healing, is looking at all these issues. But the question is, can children who are taken in adoption wait? If a person has taken a relative's child in adoption, does he live with the child in India or does he live in the foreign country of whose nationality he holds? He's got a job, he's got a family, let us say. Half the family is there, half of them is here. Or there is nobody else in the family to look after. A person is single. A person is divorced. He's living abroad alone, he's got a job. Should he wait for Kara to process for 2 years, 3 years, 4 years? Does it require everybody to go to court? Why cannot Kara be headed by a retired honorable judge who has judicial acumen, who has judicial training, who has judicial wisdom, who can look at things more objectively and decide these issues? I can never forget that Justice Ruma Paul authored a judgment in 1984 in Anokha. That is where Kara was hurt the most. There was a Italian couple who adopted a taxi driver's child, who the taxi driver had died and they were very attached to the family. And the Supreme Court said, no, the child has to go. No way. No rules, no regulations. There is bonding. Then came Justice Gogoi's judgment in Stephen Joan Becker. 63-year-old lady adopted a 10-year-old girl child. Bonding took place. Kara said you can't do it because the age gap is too much. It is not permissible. Family Court rejected it. High Court rejected it. Supreme Court overturned the judgment. These matters where children are taken in adoption, there is a home. There is bonding. There is right to family life. Now, we have also in India, as I told you earlier, signed the United Nations Convention on the Rights of the Child, where a child has a right to family life, a child has a right to a nationality, a child has a right to a home, a child has a right to live with parent. And under Article 21, right to life means right to family life. So, can procedural bureaucratic hurdles, can application of rules, regulations, and provisions contradict statutory laws applicable to communities as personal laws and take away vested rights of adoptive parents and children taken in adoption? Now, the JJ Act itself talks about social integration, rehabilitation, adoption, finding homes for children. So, can Kara be a bee in a bonnet? Can Kara keep upsetting the apple cart all the time? Can Kara start filing stereotyped replies in court without talking on merits and quoting the rules and regulations? To a great extent, knowledge is dearth. We do not have specialized family law bars. We don't have specialized family court judges or even family divisions of benches in the High Court. So there is lack of awareness. I must admit, people do not know the nitty-gritties, and it is difficult at the lower levels. It is very difficult to be fine printing into these things. I am a resource person in academies, judicial academies. I am also a law teacher, and I'm also an author of 9 books. So I know that there is a lack of awareness, and people do not know the nitty-gritties. But is it not the duty of Kara to be more transparent, to be more objective, to be more helpful, and to be more realistic and practical, rather than citing rules, making people trek up and down to Kara, sending them back to committees for approvals? Why can't there be a more simple, transparent system for intercountry adoptions? The Convention on Adoptions has given the liberty to a country who is a signatory to approve a domestic adoption if it is in application or in accordance with the local system of law. So in India, there is an approved and accepted system of adoption under HAM. Why can't Kara have an honorable judge, a committee of an honorable judge sitting within Kara to look into the adoption and verify it, instead of sending people to committees and then the committees going to district magistrates? The question which I put to myself is, do these people have the acumen, training, understanding, and knowledge of what they are doing? No, absolutely no. What does a district magistrate do about adoption? He has a checklist. He has a pro forma in the regulations. He just does tick mark and does it. Where is the application of mind? Where is the best interest and welfare of the child evaluation? I think by giving it back to a district magistrate from a court, they have taken away the process of application. A child is not a contract, quota, or a permit that the district magistrate will issue it. It will only lead to systematically, without application of mind, certificates being issued. And do these committees, constituted of social workers or people not trained or lettered in law, do they have the infrastructure, mental makeup, judicial acumen, or capability to approve an adoption or look into the nitty-gritties? The answer is no. Now, any guardianship, any visitation right, any custody other than adoption, under any other law, would go to a family court. Under the Family Courts Act, read with the Guardian and Wards Act. So can you take away the jurisdiction of judicial courts on a domain in the area of the Family Courts Act by vesting it to a district magistrate? The answer is clearly no. The Family Courts Act says in Section 7, this is its jurisdiction. And under Section 8, it says any other district court will not have jurisdiction in this matter. If there is no other court which has jurisdiction in a matter related to the Family Courts Act, how on earth can a district magistrate get jurisdiction? Are we watering down other laws in a zeal and a zest for Kara to take over the entire process of adoption? This is the larger picture. So, all listeners, lawyers, affected people, friends, associates, this is the rundown on scenario which I can give you best in about an hour's time. Now, I leave the floor to any and everybody to ask me any question connected with what I have just spoken. If somebody has a problem, that's welcome. If somebody has a query, that's open. And if somebody has a comment, feel free. So,
anyone who wants to ask questions, they can unmute themselves and they can ask. We can have an interactive session. Before that, there is one question in the chat box.
Yes.
By
Yes.
Advocate Pallavi.
Yes.
What will be the
Yes,
procedure
ma'am.
to incorporate the name of the adopted parents' name in the birth certificate of child after adoption under HAMA?
I think if you have adopted a child under Hama, you have taken the precaution of writing an adoption deed. You can easily, I have seen people having no problem. They go to the registrar of births and deaths. They produce the document. They produce the adoption deed, and a second birth certificate is issued recording the names of the adoptive parents. You can even get an Aadhaar card. You can get a birth certificate, you can get an Aadhaar card, but the problem comes when you have to get a passport. Then Kara NOC comes. So till that stage, there is absolutely no problem. So now that brings us to another very interesting input. Suppose the adoption is domestic. You do the adoption, you take the precaution of writing a deed, getting it attested, notarized. You also get a birth certificate. You get the child admitted in a school. Everything is fine. All goes on. Nothing happens. There has been a reported case in Kerala where this happened. But then the CWC one day went and picked up the child, saying you have not followed the procedure. The matter went to the High Court. It's a reported case, Siva Rama's case, 2003, I think. And in a habeas corpus, the court directed CWC return the child. Who are you? So now this is another Quandary's issue. If the child is not to leave the country and is within India domestically, then everything is all right. No CWC, no checks, no inquiry, no verification. But the moment you have to take the child out of the country, then there is a system of checks and balances. So there is a artificial classification without any nexus with the object thought to be achieved by dividing Hindu adoption in two parts. So a Hindu adoption within India is valid without a Kara NOC. A Hindu adoption for a child to be taken outside India is invalid without a Kara NOC. Makes no sense. Second question. Shraddha, back to you.
There are no further questions, but if anyone wants to have, interactive session with sir or any queries, they can unmute themselves and they can ask the question.
Anybody can ask anything, please. If anybody has any question, please feel free.
Sir,
Yes.
एक्चुअली महाराष्ट्र में अभी जो जेजे में अमेंडमेंट्स हुए हैं वो स्टे है, लेकिन अगर हम हम्मा के अंडर एडॉप्शन करते हैं तो जब भी हम बर्थ सर्टिफिकेट के लिए जाते हैं तो कोर्ट ऑर्डर मांग लेते हैं। हालांकि अभी हाई कोर्ट का एक जजमेंट भी है जिसमें सब इश्यूज डिस्कस किए गए हैं और जिसमें बताया गया है कि कोर्ट ऑर्डर की कोई जरूरत नहीं है। फिर भी हर बार हमसे कोर्ट ऑर्डर मांगी जाती है। अभी हम्मा के अंडर हम लोग जाएंगे तो वहां पे कोर्ट हमें बताता है कि ठीक है, नहीं आप हम क्या इसमें कर सकते हैं, आपका एडॉप्शन डेट तो रजिस्टर है तो आपको कोर्ट के ऑर्डर की कोई जरूरत नहीं है। लेकिन इन दैट केस कैन वी फाइल अ डिक्लेरेशन सूट फॉर दैट पर्पस?
देखिए ऐसे है, आप डिक्लेरेशन सूट भी कर सकते हैं, बट डिक्लेरेटरी सूट में आपको कम से कम 2-3 साल लग जाएंगे। एविडेंस कराओगे और लिटिगेशन होगी, डेटें बढ़ेंगी। इससे अच्छा है कि आप एक हाई कोर्ट में रिट डालिए अंडर 226 कॉन्स्टिट्यूशन ऑफ इंडिया, जिसमें आप डायरेक्शन सीख कीजिए उसको, रजिस्ट्रार ऑफ बर्थ्स एंड डेथ्स को, भाई यू आर अ स्टेट अथॉरिटी, यू आर obliged under the law to issue a birth certificate. And कहाँ लिखा है कि कौन से कानून में लिखा है कि आपको कारा का एनओसी चाहिए या कोर्ट की अप्रूवल चाहिए? जब हिंदू लॉ में लिखा हुआ है, सेक्शन 12 में लिखा हुआ है, आपने अडॉप्शन डीड कर ली, आप अडॉप्शन कंफर्म हो गई, तो ये कौन से कानून में लिखा है कि आपको कहीं से अप्रूवल या कहीं से ऑर्डर लाना पड़ेगा? सो आप कॉन्स्टिट्यूशन ऑफ इंडिया में फंडामेंटल राइट्स की इन्फोर्समेंट में लार्जर पिक्चर प्रेजेंट करके आप रिट कीजिए. डिक्लेरेशन में आपको क्या मिलेगा? डिक्लेरेशन तो ऑलरेडी इनबिल्ट है हमा के अंदर. So what is more important for you is not to get into procedural issues. Simply go to the High Court in a writ. 2 or 3 hearings will be resolved. Because the judge will say where is the provision for the refusal. ऐसे ही passport के लिए है. So I don't think आपको कोई complication आनी चाहिए. And let us take the situation further. Let us say that आपको passport चाहिए. So you go to the passport officer and say, I have adopted this child. Here is the adoption deed, in which it is recorded that the adoption is taking place as per Hama. The passport officer will not refuse you a passport because you are living in India. You want an Indian passport. So likewise, the registrar of births is not. He cannot refuse. Don't file a declaratory suit. File a writ. Quicker, faster, better.
Okay, thank you, sir.
Anybody else?
Anyone else?
Yes.
Sir, hello. Sir, I'm having one question.
Yes.
सर, एक आदमी अगर हिंदू आदमी किसी बच्चे को अडॉप्ट करता है तो बच्चे का जो कास्ट सर्टिफिकेट है तो वो उसके जो बायोलॉजिकल फादर है उनके ही नाम से होता है ना?
देखिए मैडम, बात बड़ी सिंपल है.
हाँ.
The child will lose
हाँ.
and sever all ties with the natural family.
Okay.
So I think logically,
Okay.
issues like caste
Oh,
will also lose relevance.
okay. It will lose relevance.
Absolutely, because
Hmm.
you cannot say that the child was of this caste,
Hmm.
was adopted, when he was not adopted. Now the child is adopted, but he still retains the caste of his natural father. उसमें
Okay.
section 12 में लिखा है that the child will sever all ties. His rights of property, his rights of shares of the issues, and likewise the rights of caste. If he has
Okay.
some rights accruing to there are some rights accruing to the child,
Okay.
which are not whose benefit has not been taken as of now.
Okay.
They will remain. They will go away. Whatever benefits have been taken have been taken.
Okay.
But whatever has not been taken,
Hmm.
he cannot say, no, my natural father was so and so caste.
Okay.
Therefore, I will want that benefit from that caste. That is not possible. It's a complete severance.
Okay.
There is a complete, it's complete. Section, आप देखो ना, let us
Yes.
very quickly run through section 12.
Okay.
Section
सर
12.
अगर कास्ट सर्टिफिकेट बना दिया गया हो तो फिर क्या वो चेंज कर सकती हूँ मैं?
देखिए,
हाँ.
आपका if you have a caste certificate,
Yeah.
caste certificate will obviously mention child X, son of Y, caste so and so. Caste certificate में father's name तो जरूर होगा ना?
जी बिल्कुल बिल्कुल.
So if you go around claiming your caste by virtue of the caste of your natural father, obviously that will go.
Okay.
But if you want another caste certificate of the adoptive parents' caste, that you can get. Because section 12, let us read the provision and let us see what the provision has to say.
Okay.
Section 12 of Hama, just Section 12 says, an adopted child shall be deemed to be the child of his or her adopted father or mother for all purposes. For all purposes. With effect from the date of the adoption, and from such date, all the ties of the child in the family of birth shall be deemed to be severed and replaced by those created by the adoption in the adoption family. So I think it is very clear that for all intents and purposes, the ties shall be severed.
Okay.
So, all intents and purposes, I think, is a very vast, encompassing term, and it will cover all possible situations. I
Okay.
think it's a package. You have to take it. You can't say the good ones I'll take, the bad ones I don't want.
Okay. Yes, right.
And why should you give the child a dual conflicting personality or a dual identity?
Right. That's why I asked you a question.
I mean, he should not be in a conflict where he says where he's told you are so and so caste by birth, you are so and so caste by adoption.
Yes. 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 He will face
I
the
don't
problem.
I don't think that is fair to the child also.
Okay. And I can change the name of the child in the birth certificate also, means father's name.
Yes, you can change. You can even change the
Okay.
name of the child. Father of the child's name you will change, obviously.
Okay. Yes.
So
Okay.
adoptive father will become the father. The change will be
Okay.
effected in the records. See, the child has to grow up. He has to go to
Yeah.
school. He needs a
Yeah.
birth certificate. He needs a class 10
Mm.
certificate. He needs a
Yes.
passport. And
Yeah.
most of all, he needs an identity in society.
Right.
Once he's
Okay.
taken in adoption, he can't say that the father who gave me birth was so and so, but the father who has adopted me is so and so.
Right. Okay.
So
Okay.
I think that is the logic.
Yeah.
That is the logic of law.
Yes.
You can't say I was born in so and so family.
Right.
Now I am in so and so family, but all my rights of property are in the old family.
No, it won't happen.
Yes, Shraddha, any other question?
Thank you, sir. Thank you.
No problem.
Sir, I have a question.
Yes.
It's actually if both are NRIs, one is staying in Dubai and one is staying in Australia, they are getting remarried and both have children. So in such case, whether they will proceed for adoption as per Hindu Marriage Act agreement or as per their respective countries where they are settled.
We have to go slowly on your question. First of all, tell me where are the adoptive father and mother?
Adoptive father stays in Australia.
Right.
And the natural mother guardian stays in Dubai.
Okay.
And both are getting remarried with each other only.
Remarried I don't understand this. You'll have to be more elaborate.
There is a remarriage between X and Y, wherein X is a lady.
X and Y are what? Adoptive parents giving an adoption or taking an adoption?
No, parent is a single parent. X and Y are getting remarried, and in such case, the mother has two daughters.
Just a moment. X and Y are getting remarried. Are getting married. Remarried.
Getting married. Yeah.
Are getting married. They have suffered they have had one marriage before.
Yes.
So they are divorced or somebody is gone or whatever. So X and Y are getting married.
Yes.
And the lady has two daughters.
Yes.
And has the man also got children?
Yeah, he has a son, but his wife, he is taking the custody of the son.
So he's divorced.
Yes.
So he's divorced and he has a son.
Yeah.
So now they are wanting to adopt a child. And are they Hindus by religion?
Yes, both are Hindus.
Yes. See, you will have no problem doing it under Hindu law, but there is a difficulty. The difficulty is that under Hindu Adoption and Maintenance Act, you can adopt a son if you don't have a son. Now, let me just point out to you. Section capacity of a male to take an adoption, section 7. Then section 12. If the adoption is of a son, the adoptive father or mother by whom the adoption is being made must not have a Hindu son, son's son or son's son living at the time of adoption. So if you have a son you cannot adopt a son.
Okay.
If you have a daughter, you cannot adopt a daughter.
Okay.
So you can do your adoption under Hama. Why did you have no son? Otherwise, there is no problem. So what will you have to do? You will have to do your adoption under the JJ Act. Because under the JJ Act, there is no such power. So you will have to do your adoption under the JJ Act and follow the procedure there. So you will have to you cannot say that I have done my adoption under Hama and I want approval under the JJ Act. You will have to do the adoption under JJ Act itself. Because you would, if you had no son, you could have adopted under Hama. And as I said in my earlier part of the lecture, whether you are Italian, German, Swiss, whatever, you are Hindu by religion, you will remain Hindu by religion. Your rights as Hindu will not go away. But then if under Hama you are disqualified because you have a son, then that is a different story.
Okay, now here she has two daughters and he has a son. So I think there is no problem in, adoption.
So there is no problem in adoption under Hama, but but the man cannot adopt another son.
No, it's daughters. He is adopting daughters.
He is adopting daughters, but his wife cannot adopt them. His wife is disqualified. The lady whom she's remarried, he can adopt the girls alone. But there is a problem here also. If the adoption is of a daughter, okay, now there is another condition. Suppose the father is adopting the girls alone. It will say, if the adoption is by a male and the person to be adopted is a female, adoptive father should be at least 21 years older than the child to be adopted. So there must be a 21-year-old gap.
Yes.
Between the father and the girls. So if you have the gap, you can do the adoption. The man can adopt the girls on his own.
Okay.
He can, because the mother is already a guardian. She's the guardian. So if you have a 21-year-old gap between the father and the adoptive daughters, you can go ahead with the adoption.
Okay. Got it. Thank you.
Yes. Anybody else?
Sir, I have one question.
Yes.
This question is just related to the earlier one which Advocate Preeti has asked. In this situation, if the widower remarries and she has a daughter as well as a son, so in such situation, how the adoption will take place? As you mentioned that the son cannot be adopted, but when the widow is remarrying to a person, she cannot leave the son alone and just come with the daughter. So in such situation, how to work it out?
I'll tell you the way out. The way out is that the man whom she is remarried, if he does not have a son, he can adopt the son alone.
Okay.
Because the mother is already the natural guardian.
Yes.
So the man can adopt the son alone.
Okay.
Under Hama. Do the adoption, register a deed and sit quietly at home.
Okay.
If you are within India, wonderful. Get a fresh birth certificate, get a fresh passport, and live within India happily. The problems come when you... So the way around is that when you get remarried, the other parent adopts. Provided if he's got a son already of his own, then he can't adopt a son. If he's got a daughter, he can't adopt a daughter. But he can adopt a child of the opposite sex who is the child of the woman whom he's remarried.
Okay. So, but then again, the problem is that as in the earlier discussion, it was said, like in Maharashtra, especially in Mumbai, some registrar, they accept this adoption deed and they do the registration. But when we approach the BMC office, they ask for the court order. So the challenges come over there that
What is DMC?
Sir, here the local authority who is giving the changes in the birth certificate, or who is issuing that is a Mahanagar Brihan Mumbai Mahanagar Palika. So we have to approach for the changes in the birth certificate and all that. We have to approach the BMC. So
Madam, the answer is very simple. There is no point wasting your breath with clerks, administrative officers who don't know law. You go to the High Court in a writ. I know you have to spend money and put some time, but I think the High Court writ petition is the best answer under 226. Declaratory suit or getting an injunction or getting a declaration is a long process. You will have to file pleading, you'll have to serve, you'll have to get evidence recorded. It will take 2 to 3 years. If you go in a writ, you tell the judge, this is what I've done, this is the law, he will issue a direction and you will get relief straight away. I think High Court order nobody wants to violate.
Yes.
Simple.
Thank you, sir. Thank you.
There is one question in the chat by Advocate Mandar Sawant. Can I read that, sir?
Yes, please.
Just hold on. Yeah, if parents of a child have expired in COVID and the child is residing with relatives who are related to adoptive parents, should they go approach CARA for adoption, or they can go under HAMA?
No. I think there is a provision under HAMA itself. I will read out section 9, subsection 4 to you, where both father and mother are dead, or have completely and finally renounced the world, or have abandoned the child, or have been declared by the court of competent jurisdiction to unsound mind, or where the parentage is not known, the guardian of the child may give the child in adoption with the previous permission of the court to any person, including the guardian himself. So, Shraddha, what happens here? That under HAMA, you as the guardian of the child can give the child in adoption to yourself. But you will have to go to the family court or the guardian judge to get this approval. You will not have to go to CARA. You will not have to go to the JJ Act. You will, under section 9(4), do the adoption by virtue of section 9(4), and you are the guardian. And under 9(5), before granting permission, the court will satisfy that the adoption is for the welfare of the child. So you have a simple, straight, shortcut method under 9(4), 9(5) of HAMA. So, anybody else with any other question?
Anyone else who wants to ask the question, they can unmute themselves. I think there are no other questions.
Fair enough.
Okay, before winding up, I'll just, post one link, or I will broadcast everyone about Sir's article on this international adoption.
Yes, please.
Sir, I have one question.
Yes, please.
To know if both the parents are divorcee,
Okay.
both have one child. Like man has one child and wife has one child, and they are both marrying. Then how will the adoption will take place?
See, the father, the husband will adopt his wife's child.
Yeah. Okay.
But they should be opposite sex.
Okay.
And the wife remarrying will adopt her husband's child.
And in case both have daughters or both have male child, then in that eventuality, what will happen?
See, you will need to go under the JJ Act then.
Okay.
Because there is a bar of adoption under HAMA.
Okay.
You can't adopt a girl. So,
okay,
the person you are marrying has a girl and you have a boy, you are okay.
Yes, sir.
So, if there is an opposite sex, it's okay.
Okay.
But otherwise, there is a problem.
There is a problem.
And Suppose you don't want to go under JJ Act. I think if you are living in harmony,
Okay.
these formal orders may be just a formality.
Okay.
That is the
Well,
best. You have to compromise somewhere. But
okay.
if you have an answer, but see, JJ Act is pretty complicated.
Okay.
But then you can go to Kara. They can process your papers. They can get a district magistrate's report. There is a
Okay.
procedure laid down under JJ Act for domestic adoptions.
Okay. Okay, sir.
Follow that procedure. If you want to be very sure and legal, if you want change
Okay.
in birth certificate, in passport, and Aadhaar card, then
Okay.
you will need a proper certificate or a document. Only then
Okay.
changes will take place. In
Okay.
Aadhaar card is, see, nowadays everything hinges on the Aadhaar card, the PAN card,
PAN card. Right, sir.
and everything is connected by KYC.
Please, sir. Sir,
If you don't do KYC, you can't operate a bank account. You can't get a driving license. You cannot get a vehicle.
please, sir. Sir, one question I have more.
Yes.
Sir, in case, sir, wife has divorced her husband and this person has also divorced his wife. Now, in that eventuality, both the children are having same sex, like both are boys or both are girls. Whether any requirement is there for parents, also the parents like man, wife, wife and other person. I want to know that.
For what?
Sir, like the man divorces his wife but keep the custody of the son. And on the other hand, the wife to whom he is getting married, she also has a son. Now, whether both these persons need to take permission from the earlier spouses?
See, you are married, you divorce.
Yes.
When you divorce under the Hindu Marriage Act, all issues of custody, guardianship,
Please.
division of property are settled. It is decided that the parent, mother or father, will have the custody of the child.
Please.
Right? So that
Right.
custody is decided and the other parent takes visitation right. For example, parents are getting divorced. Mother says, I don't want custody, I only want visitation. Custody goes to father.
Please.
Or custody goes to mother, visitation goes to father.
Please.
This arrangement will be applicable in the second marriage.
Okay.
And there will be no interference of rights.
Okay.
Now, if a person is marrying another person, knowing fully well that the custody of a child from a previous marriage is with the person,
Okay.
he or she is accepting the person with the child. And if it is, and if both the parents who are divorcees are remarrying, knowing fully well that they are accepting each other's children, then who has a problem? The answer is, जब मियाँ बीवी राजी तो क्या करेगा काजी?
That is very true, sir. But as per our Hindu law, like the son who is born in a Hindu family, he has a right in the father property, ancestral property.
But then you see, if the child is coming after divorce with the father,
with the from the mother side, from the wife, other female side.
Yeah. So let us suppose the child is coming from the mother's side.
Please.
So he has the custody is with the mother.
Please.
The father has said, I don't want anything to do with it.
Please.
Now the child will have rights in his father's property.
Please.
Under the Hindu Succession Act.
Please.
Because he's a class 1 heir.
Class 1 heir, right.
But if his divorced father makes a will,
please,
and excludes him from any share of in his property, then the boy is out.
Boy is out.
Boy is out.
Boy is out.
But if the mother remarries a man and that man adopts the child,
please,
then the boy will lose all his rights in his natural father's property.
Okay. Right. Okay. Okay, that was my question.
Yes, that's it.
Thank you so much.
There is
And
one last question on the chat
Yes,
by Advocate Rajeshwari.
yes.
Is it not better to change the name by declaring in government gazette rather than the change the birth certificate?
What? Come again? I didn't understand the question.
Basically, for the child's name, it is her question is like, is it not better to change the name of by declaring in the government gazette rather than change in the birth certificate?
See, how many people will read the Gazette
Hmm.
and for what purpose? Is it a public document? Today Shraddha, we are talking in terms of rights of privacy. Names of children should not be put in public domain. A lot of court use acronyms. They use alphabets. So
Yeah.
publicizing a child's name as having been taken in adoption may be an invasion of right of privacy. You have a 9-judge constitution bench talking of a right of privacy. So I don't think that is a good idea. I mean, in a time and an age where you have a right to be forgotten and you have a right of privacy and you have a right of confidentiality, in foreign countries, no judgment carries the name of the child at all. Here, in a lot of courts, it is not disclosed. Somewhere it happens. So that, I think, is not a good proposition. And it is not a healthy in the interest of the child. Why should a child who was taken in adoption at the time of birth or just after birth, why harm him at a mature age and say, oh, so you were adopted?
Hmm. Okay, I'll just, anyone else, anyone have any more questions to ask? They can unmute themselves.
Somebody, Vaishali Khare, wanted to confirm my understanding that since 17 September, can you just read out, Shraddha, what is this?
Yeah, sir. Wanted to confirm my understanding that since 17 September 2021, the CARA is the authority without whose no objection certificate adoption procedure cannot be fulfilled even under HAMA. Is it correct?
Now, you see, 17th of September 21 is only a date to describe the method of CARA NOC. CARA NOC for inter-country adoptions is a must. Before 17th of September 21, CARA's NOC is only to say that the adoption done within India is in accordance with the provisions of the convention. Now, after 17 September 21, CARA's NOC is to say that adoption has been done in accordance with the provisions of the JJ Act and the rules. So CARA NOC was always there before and after. It is just the procedure and the requirements which have been made more tough.
I hope, Vaishali, that is clear to you now. Anyone else? Any further questions?
Yeah, thank you, sir. Thank you very much.
Okay, all the best.
Sir, I just wanted to confirm, right, as per our earlier discussion, that after remarriage, if the child is adopted, not regarding remarriage, if the child is adopted by the father, then he loses his right over his original father's property.
Yes.
Right? Okay.
Is there any more questions? Okay, then we will end up our session. I request my colleague, Advocate Chinmay, to propose vote of thanks.
Thank you, Shraddha. Firstly, I would like to thank Sir for giving us this valuable time. So it is indeed worrisome that the child's rights and interests are often lost in the technical lacunas and the practical difficulties in implementation of the CARA policies. And it was very interesting to know. Thank you so much for giving us your time.
Thank you.
I would like to thank Shraddha for organizing this entire lecture and helping all of us understand the HAMA and the AGA better. And last and most importantly, I would like to thank each and every one of the audience members. Because of their active participation and interest in the matter, this lecture was a great success. Thank you, everyone.
Thank you very much. Thank you.
Thank you, sir. Thanks a lot.
Thank you. And do
Yeah.
send me the recording because there's a
Yeah,
lot
I'll send you by evening. I'll send you by evening once I receive.
Okay. Thank you.
Yeah. Thank you, sir. Thank you, everyone.